La Cour
Please be seated. The sitting is open. For reasons made known to me, Judges Tomka, Bandari, and Brandt, who duly participated in the deliberations and the final vote in this case, are unable to sit with us today. The Court meets today pursuant to Article 58 of its statute and Article 94 of its rules to read out in open court its judgment on the preliminary objections raised by Azerbaijan in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. Shortly after the completion of the reading of that decision, a second sitting will be held for the purposes of the reading of the Court's judgment on the preliminary objections raised by Armenia in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination, Azerbaijan versus Armenia. I recall that the proceedings in the present case were instituted on September 16, 2021 by Armenia against Azerbaijan concerning alleged violations of the International Convention on the Elimination of All Forms of Racial Discrimination of December 21, 1965. I shall refer to that convention as CERD or the Convention. Before delivering the Court's judgment in this case and subsequently in the Azerbaijan versus Armenia case, I shall briefly summarize the general background common to both cases. Armenia and Azerbaijan, both of which were republics of the former Union of the Soviet Socialist Republics, referred to as the Soviet Union, declared independence on September 21, 1991, and October 18, 1991, respectively. The region which Armenia calls Nagorno-Karabakh and Azerbaijan calls Karabakh was in the Soviet Union an autonomous entity or oblast with a majority of Armenian ethnic population lying within the territory of the Azerbaijan Soviet Socialist Republic. The parties' competing claims over that region resulted in hostilities to which Armenia refers as the First Nagorno-Karabakh War and Azerbaijan refers to as the First Karabakh War that ended with a ceasefire in May 1994. Further hostilities erupted in September 2020 in what Armenia calls the Second Nagorno-Karabakh War and Azerbaijan calls the Second Karabakh War. On November 9, 2020, the President of the Republic of Azerbaijan, the Prime Minister of the Republic of Armenia, and the President of the Russian Federation signed a statement referred to by the parties as the Trilateral Statement. Under the terms of this statement, as of November 10, 2020, and I quote, a complete ceasefire and termination of all hostilities in the area of the Nagorno-Karabakh conflict was declared, end of quote. However, the situation between the parties remained unstable and hostilities again erupted in September 2022 and again in September 2023. I now turn to the judgment on the preliminary objections in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. In accordance with the usual practice, I shall not read out the introductory paragraphs of the judgment, which set out the main elements in the procedural history of the case. I shall also omit some paragraphs and summarize others. I shall therefore begin reading the judgment at paragraph 34. The full text of the judgment will, of course, be available at the close of the sitting. In its application, Armenia alleges that Azerbaijan has breached several provisions of CERT by virtue of a decades-long state policy of racial discrimination. Specifically, Armenia asserts that, and I quote, as a result of this state-sponsored policy of Armenian hatred, Armenians have been subjected to systematic discrimination, mass killings, torture, and other abuse. End of quote. The court notes that Armenia seeks to found the court's jurisdiction on Article 36, paragraph 1 of the Statute of the Court in conjunction with Article 22 of CERT. Azerbaijan raises two preliminary objections to the jurisdiction of the court. First, it argues that the court lacks jurisdiction under Article 22 of CERT because the precondition of negotiation has not been satisfied. Second, Azerbaijan contends that some of Armenia's claims are not within the court's jurisdiction rationale materiae under Article 22 of CERT. The court starts by considering the first preliminary objection concerning whether the precondition of negotiation under Article 22 of CERT has been satisfied. As the court has observed in a previous case, in order to meet the precondition of negotiation in the compromissory clause of a treaty, the subject matter of the negotiations must relate to the subject matter of the dispute, which in turn must concern the substantive obligations contained in the treaty in question. Further, the negotiations are attempted or have commenced. The precondition of negotiations is satisfied only when negotiations have failed or when they have become futile or deadlocked. Whether negotiations have taken place or whether they have failed or become futile or deadlocked depends on the facts and circumstances of each particular case. The court notes that the parties began exchanging written correspondence related to the present disputes under CERT in November 2020. Armenia initiated correspondence with Azerbaijan by a letter dated November 11, 2020, in which Armenia alleged ongoing violations of multiple provisions of CERT. In its response, dated December 8, 2020, Azerbaijan, and I quote, rejected Armenia's allegations as set forth in its November 11 letter, end of quote. Azerbaijan also stated that it, and I quote, remained open to negotiating this matter, end of quote. Armenia reiterated its claims under CERT in a letter to Azerbaijan dated December 22, 2020, and Azerbaijan maintained its rejection of Armenia's allegations in its response dated January 15, 2021. In the court's view, these specific references to CERT show that the subject matter of these exchanges related to the subject matter of that convention. The court observed that over the subsequent months, the parties engaged in multiple written exchanges and 2 rounds of virtual meetings concerning the modalities, scope and timing of negotiations regarding the substance of alleged violations of CERT. In the court's opinion, all these exchanges formed part of the negotiations between the parties related to a possible settlement of the present dispute. Negotiations dedicated to the substance of alleged violations of CERT began with the face-to-face meeting on 15 and 16 July 2021 during which Armenia presented its claims and requested remedies. The parties held 2 rounds of in-person meetings to negotiate claims and remedies. The first on 15 and 16 and 27 and 28 July 2021, and the second on 30 and 31st of August and 14th and 15th of September 2021. The Court observed that the parties' respective positions remain substantially unchanged from Azerbaijan's initial rejection of Armenia's claims in December 2020 until it renewed the rejection of those claims at the parties' second substantive meeting in September 2021. The Court further noted that Azerbaijan presented specific proposals to Armenia at the 30 and 31 of August 2021 meeting and communicating them again by letter to Armenia dated October 9, 2021. These proposals were for certain joint action that Azerbaijan and Armenia might take rather than proposals capable of resolving the present dispute under CERD. Against this background, the Court is not persuaded by Azerbaijan's argument that such proposals provide a basis for concluding that the negotiations had only just begun and that further negotiations could still have led to a settlement. The Court is of the opinion that Armenia made a genuine attempt to engage in discussions with Azerbaijan with a view to resolving the dispute as required by Article 22 of CERD. Further, the Court is of the view that these negotiations had become futile by the date on which Armenia filed its application. The Court recalled that evidence of a genuine attempt to negotiate or of the conduct of negotiation does not require that the parties to a dispute have in fact reached an agreement. In past cases, the Court has found that a precondition of negotiation was satisfied when the parties' basic positions had not subsequently evolved after several exchanges of diplomatic correspondence or meeting. Moreover, the Court has held that the actual number or duration of exchanges is not dispositive in this regard. In the present case, the parties' respective positions remained substantially unaltered between the end of 2020 and September 2021. In light of these circumstances, the Court considers that negotiations had become futile because there was no realistic possibility at that stage of a bilateral negotiated settlement of disagreement between the parties. For these reasons, the Court concludes that the precondition of negotiation under Article 22 of CERD is satisfied in the circumstances of the present case. As a result, the Court concludes that the first preliminary objection raised by Azerbaijan must be rejected. The Court then examines Azerbaijan's second preliminary objection, which concerns the Court's jurisdiction ratio in materie. The Court recalls that in accordance with Article 22 of CERD, its jurisdiction ratio in materie covers, and I quote, any dispute between 2 or more states parties with respect to the interpretation or application of this convention. End of quote. Recalling its jurisprudence, the Court observed that when it is seized on the basis of a treaty's compromissory clause by a state invoking the international responsibility of another state party for the breach of obligations under the treaty, it must be ascertained whether the actions or omissions of the respondent complained of by the applicant fall within the scope of the treaty allegedly violated. In other words, whether the facts at issue, if established, are capable of constituting violations of obligations under the treaty. In determining whether it has jurisdiction ratio in materie, the Court recalls that it does not need to satisfy itself that the acts of which Armenia complains actually constitute racial discrimination within the meaning of Article 1, Paragraph 1 of CERD. Such a determination concerns issues of fact, largely depending on evidence regarding the purpose or effect of the measures alleged by Armenia, and is thus properly a matter for the merits, should the case proceed to that stage. At this stage, the court must ascertain merely whether the alleged acts of murder, torture, inhuman treatment, arbitrary detention, and enforced disappearance, if established, are capable of constituting violations of CERD, and thus fall within the scope of the Convention. Accordingly, in order for claims to come within the court's jurisdiction ratione materi under CERD, the applicant must allege acts that, if established, are capable of amounting to a differentiation of treatment based on one of the prohibited grounds under Article 1, Paragraph 1, with the purpose or effect of nullifying or impairing the enjoyment of rights on an equal footing by members of the protected group. The Court recalled that, pursuant to Article 1, Paragraph 2 of CERD, distinctions based on citizenship or current nationality, as opposed to national or ethnic origin, do not fall within the scope of the Convention. However, in the present case, the parties concur that Armenian national or ethnic origin constitutes a prohibited ground for discrimination under the Convention, and the Court agrees with this characterization. The Court then turned to the applicability of CERD in situations of armed conflict. Its common ground between the parties that CERD applies in situations of armed conflict, and that the applicability of international humanitarian law to conduct in an armed conflict does not preclude the applicability of CERD. In particular, both parties acknowledge that conduct may be incompatible with international humanitarian law can simultaneously implicate obligations under CERD, provided that such conduct conforms to the requirements for establishing a claim under that convention. The Court notes that the prohibition of racial discrimination as an essential part of international human rights law is also a fundamental element of international humanitarian law. The Court has previously acknowledged that allegedly discriminatory acts taking place in the context of armed conflict appear to be capable of contravening rights provided by CERD, even if certain of these alleged acts might also be covered by other rules of international law, including humanitarian law. The Court recalled that the protection offered by human rights conventions does not cease in case of armed conflict. The Court further observed that the object and purpose of CERD is to eliminate racial discrimination in all its forms and manifestations. The Convention contains no general restrictions relating to its applicability in situations of armed conflict, nor does it provide for derogation in such circumstances. Indeed, some of the most extreme forms of racial discrimination occur in the context of armed conflict. Accordingly, the Court concludes that the protection against racial discrimination provided by CERD continues to apply in armed conflict. In that sense, CERD and international humanitarian law are complementary. The Court emphasizes, however, that its jurisdiction in the present case is limited by Article 22 of CERD to Armenia's claims under that convention. For these reasons, in the Court's view, acts of murder, torture, inhuman treatment, arbitrary detention, and enforced disappearance allegedly carried out on the basis of the national or ethnic origin of the victim are capable of constituting violations of obligations under CERD, including in an armed conflict. In light of this, the Court must ascertain whether the specific acts complained of by Armenia are capable of establishing discriminatory treatment based on the victim's Armenian national or ethnic origin. The court then considered the arguments put forward by Azerbaijan against Armenia's claims that Azerbaijan has subjected ethnic Armenians to acts of murder, torture, and inhuman treatment on the basis of their Armenian national or ethnic origin in violation of Article 2, Paragraph 1, as well as Articles 4A and 5B of CERT. The court recalls that unlike international humanitarian law, CERT does not distinguish between members of armed forces and civilians. In light of this, the court considers that Armenia's claims concerning the discriminatory treatment on the basis of national or ethnic origin of both members of armed forces and civilians fall within the scope of CERT. The court is of the view that the acts alleged by Armenia are capable of constituting discrimination against members of armed forces and civilians based on their Armenian national or ethnic origin carried out with the purpose or effect of interfering with rights protected under Article 2, 1, 4A, and 5B of CERT. This includes the treatment of ethnic Armenians who reside in Nagorno-Karabakh. The court observed that the consequence of Azerbaijan's submissions would be the exclusion of a claim from the court's jurisdiction Rashwani materia under CERT if some alternative explanation or interpretation of the harm alleged by Armenia is available. At the jurisdictional stage, however, the court need only determine whether the acts alleged are capable of constituting violations of CERT, and thus fall within the scope of the Convention. The court observed that racial discrimination can be a highly contextual phenomenon, and identifying racial discrimination may require careful assessment of the facts and their implications. Whether the material submitted by Armenia in support of its claims is sufficient to demonstrate that the alleged acts of discrimination in question were in fact based on the national or ethnic origin of the victims is a matter for the merits and cannot be determined at this stage of the proceedings. With respect to Armenia's claimed evidence regarding generalized anti-Armenian animus, the court has previously acknowledged in its order of December 7, 2021, indicating provisional measures that rhetoric, I quote, promoting racial hatred and incitement to racial discrimination can generate a pervasive racially charged environment, particularly when employed by high-ranking officials of the state, end of quote, and increase the risk of bodily harm to members of the protected group. The court notes that Azerbaijan has not objected to the court's jurisdiction in respect of Armenia's claims relating to its alleged glorification of racially motivated violence or hate speech against ethnic Armenians. The court considers that the alleged pervasive atmosphere of racially discriminatory speech and sentiment is relevant to its assessment of Armenia's assertion that certain acts complained of are capable of violating obligations under CERT. The extent to which such generalized anti-Armenian sentiment, if proven, can be invoked to demonstrate that specific acts were based on prohibited grounds under Article 1, Paragraph 1 of CERT, is not a question that the court needs to determine at this stage of the proceedings. Accordingly, the court concludes that Armenia's claims of alleged racially motivated murder, torture, and inhuman treatment of ethnic Armenians fall within the scope of Article 2, Paragraph 1, Article 4A, and Article 4B of CERT. The court then turned its attention to the claims concerning arbitrary detention and enforced disappearance. Taking into account the reasons set forth in its analysis of the arguments advanced in relation to murder, torture, and inhuman treatment, the Court is of the view that the acts alleged by Armenia in relation to arbitrary detention and enforced disappearance of ethnic Armenian civilians are capable of constituting discriminatory treatment based on Armenian national or ethnic origin, carried out with the purpose or effect of interfering with rights protected under Article 2 and Article 5A of CERN. This includes the treatment of ethnic Armenians who reside in Nagorno-Karabakh. Accordingly, the Court concludes that Armenia's claims regarding the alleged racially motivated arbitrary detention and enforced disappearance of ethnic Armenians fall within the scope of Article 2 and Article 5A of CERT. Thus, the Court finds that the claims advanced by Armenia in Part 6, Chapter 3, Sections 1, 3, and 4 of its memorial fall within the scope of CERT. Accordingly, the Court concludes that Azerbaijan's second preliminary objection to the Court's jurisdiction must be rejected. I shall now read out the operative part of the judgment. For these reasons, the Court, by 16 votes to 1, rejects the preliminary objection raised by the Republic of Azerbaijan. In favor, President Salam, Vice President Sebutinde, Judges Tomka, Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Clady, Judge Adok Dode. Against, Judge Adok Koroma. 2. By 15 votes to 2, rejects the second preliminary objection raised by the Republic of Azerbaijan. In favor, President Salam, Vice President Sebutinde, Judges Tomka, Abraham, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Claty, Judge Adok Dode. Against, Judge Yusuf, Judge Adok Koroma. 3. By 15 votes to 2, find that it has jurisdiction on the basis of Article 22 of the International Convention on the Elimination of All Forms of Racial Discrimination to entertain the application filed by the Republic of Armenia on September 16, 2021. In favor, President Salam, Vice President Sebutinde, Judges Tomka, Abraham, Shway, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Clady, Judge Adok Dode. Against, Judge Yusuf and Judge Adok Koroma. I now call upon the Registrar to read the operative part of the judgment in French.
Par ces motifs, la Cour, 1, par 16 voix contre 1, rejette la première exception préliminaire soulevée par la République d'Azerbaïdjan. Pour M. Salam, Président, Mme Sebutinde, Vice-présidente, M. Tomka Abraham Youssouf, Mme Choué, M. Bandari Iwasawa Nolte, Mme Charlesworth, M. Brand Gomez Robledo, Mme Cleveland, M. Orescu Tladi, juge, M. Daudet, juge ad hoc, contre M. Koroma, juge ad hoc. 2. Par 15 voix contre 2, rejette la seconde exception préliminaire soulevée par la République d'Azerbaïdjan. Pour M. Salam, Président, Mme Sebutinde, Vice-présidente, M. Tomka Abraham, Mme Choué, M. Bandari Iwasawa Nolte, Mme Charlesworth, M. Brand Gomez Robledo, Mme Cleveland, M. Orescu Tladi, juge, M. Daudet, juge ad hoc, contre M. Youssouf, juge, M. Koroma, juge ad hoc. 3. Par 15 voix contre 2, dit qu'elle a compétence sur la base de l'article 22 de la Convention internationale sur l'élimination de toutes les formes de discrimination raciale pour connaître de la requête déposée par la République d'Arménie le 16 septembre 2021. Pour M. Salam, président, Mme Sebutinde, vice-présidente, M. Tomka Abraham, Mme Choué, M. Bandari Iwasawa Nolte, Mme Charlesworth, M. Bran, Gomez Robledo, Mme Cleveland, M. Orescu, Tladi, juge, M. Daudet, juge ad hoc, contre M. Youssouf, juge, M. Koroma, juge ad hoc.
Judge Youssouf appends a dissenting opinion to the judgment of the court. Judge Iwasawa appends a separate opinion to the judgment of the court. Judge ad hoc Koroma appends a dissenting opinion to the judgment of the court. The text of the judgment is available from today in typescript. It will also be available shortly on the court's website. The printed text will be available in the near future. This brings to a conclusion the sitting in relation to the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. After a short break of 10 minutes, a new sitting will begin for the purposes of reading of the court judgment on the preliminary objections in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Azerbaijan versus Armenia. The sitting is closed.
La Cour.
Veuillez vous asseoir.
Please be seated.
L'audience.
The sitting is open. The court meets this afternoon, pursuant to Article 58 of its statute and Article 94 of its rules, to read out in open court its judgment on the preliminary objections raised by the Republic of Armenia in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination, Azerbaijan versus Armenia. I recall that on the 23rd of September 2021, Azerbaijan filed in the registry of the court an application instituting proceedings against Armenia concerning alleged violations of the International Convention of the Elimination of All Forms of Racial Discrimination of 21st of December 1965, which I shall refer to hereinafter as the CERD or the Convention. In accordance with the usual practice, I shall not read out the introductory paragraphs of the judgment, which set out the main elements in the procedural history of the case. I shall also omit some paragraphs and summarize others. I shall therefore begin reading the judgment at paragraph 26. The full text of the judgment will, of course, be available at the close of the meeting. In its application, Azerbaijan seeks to found the court's jurisdiction on Article 36, paragraph 1 of the statute of the court, in conjunction with Article 22 of the CERD. Both Azerbaijan and Armenia are parties to CERD. The Convention entered into force for Azerbaijan on the 15th of September 1996 and for Armenia on 23rd of July 1993. Armenia raises 3 preliminary objections. The court begins by considering the first preliminary objection concerning its jurisdiction ratione temporis. In its first preliminary objection, Armenia contends that the court lacks jurisdiction ratione temporis over Azerbaijan's claims concerning alleged acts that occurred between the 23rd of July 1993 and 15th of September 1996, the period during which Armenia was a state party to CERD, while Azerbaijan was not. Alternatively, Armenia contends that those claims are inadmissible. The court notes that the date identified by each of the parties as a critical date is used to define a decisive point in time for the determination of the temporal scope of the court's jurisdiction under Article 22 of CERD. The parties' contentions on the determination of the critical date, in essence, concerns Azerbaijan's entitlement to invoke Armenia's responsibility for the alleged acts that occurred at a time when CERD was not in force between the parties. In addressing that issue, the court considers that 2 questions debated by the parties with regard to the interpretation of the application of Article 22 should be dealt with at the outset. First, whether the principle of non-retroactivity of treaties has an effect on the court's jurisdiction under Article 22 of CERD. And second, whether the erga omnes partes character of certain obligations under CERD may affect the temporal scope of the court's jurisdiction under CERD. Regarding the first question, the court recalls that, under Article 22 of CERD, in order for the court to have jurisdiction, only states parties may submit their dispute to the court for adjudication, and the subject matter of the dispute must concern the interpretation or application of the Convention. This article specifies the scope of the court's jurisdiction ratione personae and ratione materie, but contains no language defining the temporal scope of the court's jurisdiction. The court considers that Armenia's reference to the principle of non-retroactivity of treaties raised an issue concerning the relationship between the substantive provisions and the compromissory clause of CERD. According to the principle of non-retroactivity of treaties, as reflected in Article 28 of the Vienna Convention on the Law of Treaties, unless a different intention appears from a treaty or is otherwise established, its provisions do not bind a party in relation to any act or fact which took place or any situation which ceased to exist before the date of the entry into force of the treaty with respect to that party. In the circumstances of the present case, the question is whether Article 22, under which Azerbaijan has given its consent to the court's jurisdiction, provides a jurisdictional basis for the court to entertain Azerbaijan's claims in respect of alleged acts that took place before Azerbaijan became party to the Convention. The court is of the opinion that, subject to any reservation or express indication to the contrary, the temporal scope of the court's jurisdiction under a compromissory clause is determined by the scope of the temporal application of the substantive provisions of a treaty between the parties concerned. The court thus considers that, in the present case, the temporal scope of the court's jurisdiction under Article 22 of CERD must be linked to the date on which the obligations under CERD took effect between the parties. As reflected in Articles 13 and 42 of the International Law Commission's Articles on Responsibility of States for Internationally Wrongful Acts. An act of a state does not constitute a breach of an international obligation unless the state is bound by that obligation at the time when the alleged act occurs. When a state seeks to invoke the responsibility of another state, it must show that the responsible state owes the obligation allegedly breached to the claimant state. Accordingly, Since between the 23rd of July 1993 and 15th of September 1996, Armenia did not owe obligations under CERD to Azerbaijan, Azerbaijan has no right to invoke Armenia's responsibility for the alleged acts that occurred during that period. In this connection, the Court notes that, in support of its position, Azerbaijan refers to the decision rendered by the Committee on the Elimination of Racial Discrimination in the interstate communication submitted by the State of Palestine against Israel. The Court observes that there is a difference in nature between the interstate communications procedure established under Articles 11 to 13 of CERD and the judicial mechanism provided for in Article 22. The first aims to monitor compliance by states parties with their obligations under the Convention, while the latter aims to settle disputes relating to obligations which states, by becoming parties to the Convention, have accepted to undertake vis-à-vis each other. This mechanism can therefore only be used to settle disputes relating to events that occurred at a time when both states concerned were bound by the obligations in question. Consequently, the views adopted by the CERD Committee with regard to the exercise of its competence in the context of the interstate compliance mechanism are not relevant for the purposes of the interpretation and application of the compromissory clause invoked in the present case as a basis for the Court's jurisdiction. Based on the above considerations, the Court concludes that the 15th of September 1996 is the date for the determination of the temporal scope of the Court's jurisdiction under Article 22 of CERD in the present case. The Court then turns to Azerbaijan's contention that even if the 15th of September 1996 is defined as the critical date by the Court to determine the temporal limit of the Court's jurisdiction, its claims that involve continuing or composite acts that began between 23rd of July 1993 and 15th of September 1996 and continued after the critical date nevertheless fall within the scope of the Court's jurisdiction, ratione temporis. The Court notes that whether an internationally wrongful act has a continuing or composite character will depend on both the content of the obligation concerned and the circumstances of the given case. In the present case, Azerbaijan claims that Armenia's cumulative or aggregated actions and omissions amount to a practice of ethnic cleansing, which constitutes a distinct breach of CERD. It asserts that Armenia has engaged in a long-standing systematic campaign of ethnic cleansing, which began before the 15th of September 1996 and continued after that date. The Court notes that violations of certain obligations under CERD may be committed through acts of a continuing or composite nature. To decide on Azerbaijan's claim, the Court needs to determine first whether there is sufficient evidence to establish that there existed a systematic campaign of ethnic cleansing launched by Armenia against Azerbaijan during the relevant period, and, if so, whether there were continuing or composite wrongful acts for which Armenia should be held responsible under CERD. These issues are for the merits. At the present stage, all the Court is required to decide is to what extent, ratione temporis, the Court has jurisdiction over such alleged conduct. If the Court were to find, at the stage of its examination of the merits, a continuing or composite wrongful act that commenced before the critical date of the 15th of September 1996 and continued thereafter, it would follow that the respondent's responsibility with respect to the applicant would be engaged for the actions or omissions that took place after that date, which is when the relevant obligations came into force between the parties. In this regard, the Court would nevertheless not be precluded from taking into consideration facts which occurred before that date, insofar as they are relevant to its examination of the respondent's subsequent conduct, which falls within its jurisdiction. In light of the foregoing, the Court concludes that it lacks jurisdiction ratione temporis to entertain Azerbaijan's claim that there are, based on alleged acts that occurred during the interval between 23rd of July 1993 and 15th September 1996. The respondent's first preliminary objection to the Court's jurisdiction must therefore be upheld. Since the Court has found that it lacks jurisdiction over Azerbaijan's claims relating to alleged acts that occurred before 15th of September 1996, the proceedings in respect of those claims come to an end. Therefore, there is no need for the Court to consider the arguments of the parties in relation to the question of admissibility.
The Court then examines Armenia's second preliminary objection, according to which the Court lacks jurisdiction ratione materiae, under cert, with respect to Azerbaijan's claims and contentions concerning the alleged placement of landmines and booby traps. In order to rule on its jurisdiction ratione materiae, under cert, with respect to the alleged laying of landmines and booby traps, the Court must first ascertain whether Azerbaijan, in its application instituting proceedings and memorial, requested that the Court find that Armenia violated cert by the alleged laying of landmines and booby traps, or whether Azerbaijan intended to establish that the use of the weapons in question was evidence supporting its claim regarding the alleged campaign of ethnic cleansing conducted by Armenia. The Court notes that in its application, Azerbaijan does not ask the Court to determine that the laying of landmines in itself constitutes a violation of the obligations under cert. The Court observes that Azerbaijan specifies in its memorial that evidence relating to the alleged laying of landmines and booby traps has been put forward in support of its claim that Armenia has used military means as part of a policy of ethnic cleansing. In the present proceedings, since Azerbaijan is not claiming that the alleged laying of landmines and booby traps is itself a breach of Armenia's obligations under cert, Armenia's second preliminary objection is without object. The Court will consider the arguments and evidence submitted by Azerbaijan in support of its submissions concerning alleged acts of ethnic cleansing at the merits stage. In light of the foregoing, the Court concludes that the second preliminary objection raised by Armenia, seeking to exclude from the jurisdiction of the Court the claims relating to the laying of landmines and booby traps, is without object and must therefore be rejected. Finally, the Court examines Armenia's third preliminary objection, according to which the Court lacks jurisdiction ratione materiae under cert to entertain Azerbaijan's claims concerning environmental harm. To determine whether it has jurisdiction ratione materiae to entertain Azerbaijan's claims concerning environmental harm, the Court must ascertain whether the actions and omissions of the respondent complained of by the applicant fall within the scope of cert. At this stage, the Court does not need to satisfy itself that the acts of which Azerbaijan complains actually constitute racial discrimination within the meaning of Article 1, Paragraph 1 of cert. At present, the Court must ascertain whether the alleged acts of environmental harm, if established, are capable of constituting violations of cert and thus fall within the scope of the Convention. The Court notes that the environmental harm complained of by Azerbaijan consists in the alleged degradation of forests and destruction of trees classified as natural monuments, destruction and pillaging of water infrastructure, such as pipes and irrigation systems, destruction and degradation of agricultural land and vineyards, degradation of land and water quality through mining activities, neglect and mismanagement of water infrastructure, and diversion of water resources. The court further notes that the alleged environmental harm is said to concern the districts which surround the Nagorno-Karabakh region and had a majority ethnic Azerbaijani population before the hostilities that ended in May 1994. The harm is alleged to have occurred during the period when these territories were Armenian-controlled, namely between 1994 and 2020. The court recognizes that it is not to be excluded that conduct leading to harm to the environment may, in some cases, constitute an act of racial discrimination under CERD. In the present case, however, the court notes that, according to Azerbaijan itself, the alleged degradation of forests and destruction of trees in the districts formerly populated mainly by ethnic Azerbaijanis took place in pursuance of agricultural and industrial activities and a failure to mitigate wildfires. The court is of the view that Armenia's alleged actions and omissions concerning deforestation and overexploitation of mineral resources would be either commercially motivated or due to neglect and mismanagement of the environment. Thus, even if established and attributable to Armenia, they would not constitute a differentiation of treatment based on a prohibited ground under Article 1, Paragraph 1 of CERD. With regard to water infrastructure, Azerbaijan alleges that Armenia neglected and mismanaged such infrastructure in the then-occupied territories and redirected important water resources to benefit ethnic Armenians, which contributed to the degradation of agricultural land in districts formerly populated by ethnic Azerbaijanis and resulted in depriving Azerbaijanis living in areas of Azerbaijan adjacent to the then-occupied territories of potable water and water for irrigation. The court is of the view that the alleged destruction and deviation of watercourses would have impacted different ethnic groups, and not only ethnic Azerbaijanis. Such conduct, even if established and attributable to Armenia, could not be based on a prohibited ground under Article 1, Paragraph 1 of CERD. Accordingly, in the present circumstances, the court is not convinced that the alleged harm to the environment results from acts capable of constituting racial discrimination against persons of Azerbaijani national or ethnic origin within the meaning of Article 1 of CERD. Even if the alleged acts that caused the environmental harm were established and attributable to Armenia, the court considers that they fall outside the scope of CERD, since they are neither capable of constituting a differentiation in treatment based on national or ethnic origin, nor capable of nullifying or impairing by their purpose or by their effect the enjoyment or exercise on an equal footing of the human rights of ethnic Azerbaijanis within the meaning of Article 1, Paragraph 1 of the Convention. In light of the foregoing, the court concludes that it lacks jurisdiction ratione materiae to entertain Azerbaijan's claims relating to environmental harm. The third preliminary objection raised by Armenia must therefore be upheld. I shall now read out the operative part of the judgment. For these reasons, the court, 1, by 14 votes to 3, upholds the first preliminary objection raised by the Republic of Armenia, In favor, President Salam, Vice President Sibutinde, Judges Tomka, Abraham, Shue, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Oresco, Clady, Judge Ad hoc, Dode. Against, Judges Yusuf, Cleveland, Judge Ad hoc, Kuruma. 2. By 16 votes to 1, rejects the second preliminary objection raised by the Republic of Armenia. In favor, President Salam, Vice President Sibutende, Judges Tomka, Abraham, Yusuf, Shwe, Bandare, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Oresco, Clady. Judge Ad hoc, Dode. Against, Judge Ad hoc, Kuruma. By 12 votes to 5, upholds the third preliminary objection raised by the Republic of Armenia. In favor, President Salam, Vice President Sibutinde, Judges Tomka, Abraham, Yusuf, Shwe, Bandari, Iwasawa, Brandt, Gomez Robledo, Oresco, Judge Ad hoc, Dode. Against, Judges Nolte, Charlesworth, Cleveland, Tladi, Judge Ad hoc, Kuruma. 4. Unanimously finds that it has jurisdiction on the basis of Article 22 of the International Convention on the Elimination of All Forms of Racial Discrimination, subject to points 1 and 3 of the present operative clause, to entertain the application filed by the Republic of Azerbaijan on the 23rd of September 2021. I would now ask the Registrar to read the operative part once again in English.
1. By 14 votes to 3, upholds the first preliminary objection raised by the Republic of Armenia. In favor, President Salam, Vice President Sebutinde, Judges Tomka, Abraham, Shue, Bandari, Iwasawa, Nolte, Charlesworth, Brand, Gomez Robledo, Orescu, Tladi, Judge Ad hoc Dode. Against, Judge Yusuf, Cleveland, Judge Ad hoc Koroma. 2. By 16 votes to 1, rejects the second preliminary objection raised by the Republic of Armenia. In favor, President Salam, Vice President Sebutinde, Judges Tomka, Abraham, Yusuf, Shue, Bandari, Iwasawa, Nolte, Charlesworth, Brandt, Gomez Robledo, Cleveland, Orescu, Tladi, Judge Ad hoc Dode. Against, Judge Ad hoc Koroma. 3. By 12 votes to 5, upholds the third preliminary objection raised by the Republic of Armenia. In favor, President Salam, Vice President Sebutinde, Judges Tomka, Abraham, Yusuf, Shue, Bandari, Iwasawa, Brand, Gomez Robledo, Orescu, Judge Ad hoc Dode. Against, Judges Nolte, Charlesworth, Cleveland, Tladi, Judge Ad hoc Koroma. 4. Unanimously finds that it has jurisdiction on the basis of Article 22 of the International Convention on the Elimination of All Forms of Racial Discrimination, subject to points 1 and 3 of the present operative clause, to entertain the application filed by the Republic of Azerbaijan on 23rd September 2021.
Judge Tomka appends a separate opinion to the judgment of the court. Judge Yusuf appends a declaration to the judgment of the court. Judge Iwasawa appends a separate opinion to the judgment of the court. Judges Nolte, Charlesworth, Cleveland, and Glady append a joint dissenting opinion to the judgment of the court. Judge Charlesworth appends a separate opinion to the judgment of the court. Judge Cleveland appends a dissenting opinion to the judgment of the court. Judge Glady appends a dissenting opinion to the judgment of the court. The text of the judgment is available from today in typescript. It will also be available shortly on the court's website. The printed text will be available in the near future. As the court has no further business before it today, I declare the sitting closed.